Plea bargaining is a process used in the criminal justice system. There are three main elements to a plea bargain. People involved in the plea bargaining process are the judge, the prosecutor, the defendant, and the defendant's attorney. There are reasons why I believe plea bargaining is a benefit to the criminal justice system, as well as I believe that plea bargaining also has a negative impact on the criminal justice system. The plea bargaining process starts where the defendant is charged or cited, and then has the court date of initial appearance, pleads not guilty. It's a process where the prosecution and defense negotiate a disposition that fairly satisfies the interests of both parties. This process removes the need for a trial in criminal cases. Plea bargaining also occurs after someone has pled not guilty, and then has a pre-trial with a prosecutor. During the pre-trial, it is time for both the prosecutor and defendant to discuss matters at hand, potential strengths and weaknesses of the case, ways to resolve that would promote justice while taking into account the individual's or the defendant's circumstances. There are three main elements to a plea bargain, and that is making sure that the defendant, the location of the court has jurisdiction over the defendant, the competency of the defendant, as well as the bargain must be voluntary by the defendant, as well as the defendant must be informed. Some things that the bargain must include is the original offense and any amended offenses, fines that may be owed, any terms of probation that will be imposed, a guilty plea, and both parties' signature. Once those things are all on the plea bargaining or the stipulation, the next step is to request that the judge review the plea bargain or the stipulation and sign off on the plea bargain, create an order ordering whatever the judge approves in that plea bargain. I do believe that plea bargaining saves on costs and resources that are expended within the criminal justice system. It gets cases moving and processed quickly, as well as providing finality in these cases. Over the years, plea bargaining has risen tremendously out of necessity because of the overloaded criminal justice system. The dockets are overloaded and creating limited resources within the criminal justice system. Although, as we see in Brady v. U.S., plea bargaining is held as constitutional. There is no mention in the Constitution about plea bargaining. There's other things that can occur that I think bring unjust, that are unjust when it comes to plea bargaining. One of the things is that you can have similar charges between two people, but because of the resources that one person is able to expend on attorneys or when coming into their plea bargains, different results or things can occur for similar charges. This disproportionately affects people of color and people of low socioeconomic status. Pretty much money versus no money, where people with money can afford more of an attorney, a criminal defense attorney, and people who don't have the money maybe be appointed a public defender, and we know that the public defender's office is overloaded with cases as it is. So the negotiation and the defense that may be provided isn't what it could be if the person were to spend a large amount of money on a criminal defense. So that is all I have for my presentation, and thank you for watching.